just wave to me, let us know. Okay, we'll come next. Sorry, we didn't get everybody. Go ahead.
Thank you, Chairman Jeter, members of the committee. I'm Carly Hopper with Indiana Builders Association. We represent more than 2,700 builders, developers, remodelers, and their trade partners in the state of Indiana. We appreciate the opportunity to share comments with you about our members' interest in HOAs. As new subdivisions are built and include amenities like playgrounds, trails, pools, pickleball courts are the latest thing. There's a need to plan for the maintenance of those amenities as well as the common areas in the subdivisions. So the builders and developers establish an HOA with covenants, conditions, and restrictions and set the dues to provide for those shared amenities. Home buyers are made aware of the CCRs and the dues before purchasing the home, and builders and developers typically oversee the HOA until the last lot is sold and then it transfers to the homeowners. So the current state statute provides sufficient clarity on budgets, meetings, and dues, so we aren't advocating for any changes at this time. I'd be happy to answer any questions.
Thank you, Ms. Hopper. Any questions? Senator Taylor, Senator Freeman? Whoever wants to go first, go ahead. You can both go.
I defer to my good friend from Indianapolis.
Thank you to my other good friend from Indianapolis. Thank you, Mr. Chairman. I was adamant about having this as a study committee. I thought it was going to be more robust, but here's my issue. And I can tell you that this is an issue that hopefully somebody from the, I understand there's somebody from the Homeowners Association group here. It's not the current statute that concerns me. It's the activity of some of the HOAs across the state. And here's an example. Homeowners associations have the ability to attach liens to property. They also have the ability to release liens from property. What I'm seeing in my district, and I've dealt with this, is homeowners associations, especially in Indianapolis, are basically like condo owners. They have common areas and the condo owners. So they, someone owes homeowners association dues, right? The homeowners association sells it to somebody based on, hey, we've got these liens. If you pay these liens, you can be the owner of this condo. Problem is, they don't really own it. It's subject to a lien and other encumbrances, which is most likely a mortgage. And the homeowners association walks away and says, hey, we sold our interest, but, bank, you deal with it. You got this person really sincerely believes, because they don't do a title search. Most people aren't. A $15,000 transaction, you're not going to go through a title search to see if there's some other liens on it, So I'm trying to figure out what authority we've given HOAs to actually attach liens, where it came from. Is there a limit? Can they assess fees? You're saying everything's okay.
Saying everything is okay on the front end, where the builder developer still retains control. Once he or she turns it over to the owners, again, their interest at that point, they don't have an interest.
Okay, so you guys are only involved. I heard you say that. Once the last lot is sold, you guys are out of it.
Correct.
All right. Well, just keep building your house.
There may be existing contracts with property management companies.
All right.
That last for a year or two longer, but outside of that, no.
Well, we do. I think we need to have a robust understanding and a study of our homeowners associations and what the rights that they have. And I just see it all the time. And I can't speak for all of them because I know there's some good ones out there. But,
Well, I think the state statute's specific to the liens attaching for non-payment of dues, but not outside of that. In the couple of instances,
but there's fines too.
There
they
can be fines for, yes.
And they get to charge interest on those fines.
Similarly to how a city would charge you if you don't mow your grass and they come out to do it for you.
A homeowners association is not a city.
Correct.
That's the problem, okay? You don't, it's not a government entity.
It isn't, but they are private contracts that folks agree
okay.
to sign when they, join the neighborhood, buy a home in a neighborhood that's controlled by an HOA.
They sign a HOA contract, or do they sign
they're given something that says that the neighborhood they're moving into is
Okay.
is overseen by an HOA. And
Okay,
that
I
dues
just
are
wanted to
attached
make
to
sure you, because I've never heard, maybe that's what we need to do. Maybe there needs to be a document that says you're coming to this community and you're automatically, a separate document.
I think that document exists.
Isn't that in the closing
It is.
closing
It's
documents,
part
I
of the
think?
It
closing
is in the
documents.
And they
closing.
tell you what the dues are and everything?
Yes,
Yeah.
those are all disclosed, even when the house is listed.
Oh, really?
Yes.
Okay, well, see, I'm learning something already. All right, thank you. Thank you, Representative. All right, and it tells you what the amount you're gonna pay right now, but homeowner associations can increase that too, right?
Yeah.
All right.
If they have a
But they're not
meeting.
based on a budget or anything?
They present a budget annually, yes.
Okay, all right, thank you.
Senator Freeman.
Thank you. Carly, I'd love to see it, but I saw you
Do you-
earlier.
do you want me to come
I thought-
around the pillar?
I was taking up the Greg Sturwald, I thought the pillar was a good thing until now, but is there a standard rate sheet of what HOAs charge an individual homeowner for certain things? Let's say, for example, let's say a homeowner's moving out of the neighborhood and moving to a different house, and you got to prove that you're current on your dues. Like, is there a standard rate sheet of what we charge citizens for those kinds of functions?
Not that I'm aware of. There is if you do a, title companies provide essentially an Excel spreadsheet that shows HOAs, and some of them are linked to websites that you can go to that spell out what dues are. Again, a lot of the contracts that are set up with the property management companies to provide the mowing or to clean the pool aren't publicly disclosed as far as I know, but the homeowners get those estimates or know where the money's going essentially.
Well, here's when HOAs lost me. In 2017, I moved out of my house and was told that I had to provide proof that I was current on my HOA dues. So I'm nuts and took a copy of the HOA dues and a copy of my cleared check and said, well, here you go, I'm current on my dues. And they said, no, that doesn't work. You got to get a statement from your HOA company, management company. And I said, okay, fine. So I called them, and they wanted $300 of my money. Carly, let me just suggest to you that I am a gentleman that, thank God, has earned a great living in my life and could produce $300 very quickly without effort. I would not pay $300 for that piece of paper if my maker appeared in front of me and told me to do it. There is no chance that I would do it. None. And I don't think a normal citizen walking in Indiana or any other state for this matter should have to, because my God, if my hourly rate as a lawyer gets questioned, I want to know how it takes 2 minutes to produce a piece of paper from some clerk in some office to charge $300. So HOAs, look, there needs to be some revision here. Just put me on record with Senator Taylor that there needs to be some look at these quasi-governmental institutions and the amount of money that they're charging citizens that we represent that I hear from all the time.
Other comments, questions? Thank you.
Thanks.
Ma'am, can you step on up? I'm sorry, we didn't get your sign up either. Just announce yourself.
Good morning, committee, and thank you for having us. My name is Kelly Elmore. I am an attorney, a principal at the law firm of Kovitz, Schifrin, Nesbitt. We represent thousands of community associations, homeowner associations, condo, townhome associations. I'm here today as the chair of the Legislative Action Committee for CAI, the Community Associations Institute, which is a national organization comprised of homeowners, board members, attorneys, and other providers. And I am joined today by several of our committee members, including Tom Murray of the law firm of Eads, Murray, and Pugh. We prepared and submitted a position statement on the issues that I know that were presented as the study topics. So I would encourage everyone to read. We've laid it out as bullet points on each of those issues. I think some of the issues raised, though, this morning are a little bit different than the original topic issues, and I can speak to those. But primarily, I did want to speak to one issue that is very important to our membership, and that is this issue of enforcement within associations. And the great news is we just heard 2 hours from judicial officers pleading with this committee to reduce the caseload that is in front of the judiciary. And we have a proposed solution to reduce those cases. We need to work on legislation. Fortunately, our committee has prepared draft legislation that will do that by empowering and expanding the ability of an association in a responsible, reasonable manner with restrictions to actually enforce the governing documents. And for those associations who do not have that enforcement mechanism in their documents already, our legislation proposes that they also be allowed to do this. While we don't always find compelling what other states are doing, our research has shown 37 other states already have this legislation in place. I can tell you our firm represents thousands of associations in other states. It works. We can do it with restrictions and a reasonable proposed legislation that allows community associations, when there are violations or other issues in communities, to assess a penalty. As noted already by some members speaking this morning, we do anticipate the number of community associations and homeowner associations is going to rise. We are seeing a boom in development. It would be very helpful, and as Senator Freeman has raised some very good issues that we can also address in our legislation, now is the time to be proactive, to work on legislation where we can address things like caps on fees for paid assessment letters. That's already happening in other states. We can do that here. We can do it reasonably and still give flexibility to the associations. We do have a draft that we would like to submit after this hearing for consideration by this committee. And as I mentioned, we did lay out in our position statement the key points as to each of these items. And Senator Taylor, with respect to the lien issue, what you just described is a fairly rare situation. There are some nuances. I don't know if that was articulated exactly how that happens as far as when an association has a lien and a potential sale, and we'd love to talk with you about that and clarify that process. But I did want to just mention today, over 95% of owners and community associations comply with the governing documents. They want to just live in their community. They want to pay the minimum amount of assessments and simply go about their way of life, and they are complying with the governing documents. When we talk about sort of the bad actors in associations or people causing issues, it is less than 5% of the owners. What we are proposing to do is try to empower these associations that we need to continue to develop in Indiana. We want to empower them to be able to resolve these disputes effectively within their communities so they are not clogging the courts. Judge Block does not want to see our cases. None of these judges want to see them. We can get them out of the court system. To give you one final example, I just tried a case last year in Johnson County in front of Judge Barton. We sent over 20 notices to an owner about continued violations. The association had no other mechanism other than to file suit. This particular violation was an RV in a driveway that the owner claimed was a prayer temple. It was not. So we were forced to go to court. The fees on that, because of all of the exhibits and antics that were going on, was over $6,000, which Judge Barton awarded. We can cut down on legal fees for homeowner associations, and we can cut down on clogging the court system if we can just take a reasonable approach and consider legislation. I agree with Senator Freeman's statement. It is time that we revise our Homeowner Association Act, and we have solutions. I'm open to any questions.
Thank you for the testimony. Any questions? Yes, Senator Taylor and then Senator Paul after that.
Thank you. Can you clarify where my scenario was inaccurate?
So the association has the ability, after an owner fails to pay assessments, you can either generally pursue a collection action or file a lien under the law. Typically what happens is you file the lien, you wait 90 days before you can do anything. Notice is sent to the owner receives a copy of the recorded lien, so they have 90 days to address the situation. Then typically, if the association does need to pursue it and collect the balance, then a notice is sent, they still have another 30 days to comply. Then if they still don't pay or resolve the issue, then you would have to file a foreclosure action. They get notice and an opportunity to come to the court and resolve it. If they still don't pay, then typically you're filing a motion for default. So there are tons of notices that are sent along the way.
Oh, okay,
Yeah.
yeah. Yes. let me clarify. Maybe I didn't clarify. They went through the right process. I'm talking about the person who bought the property based on the fact that they knew that there were liens and they had a default judgment. And the homeowners association, because they had a default judgment, sold what the property to a third party.
Sure.
You telling me that doesn't happen?
It's very rare, and what typically happens is, if the association sells property for a lien, let's suppose the association's lien is $2,500.
Right.
If the property sells and there's a surplus after any mortgage company is paid, the association receives its balance, and then typically the owner would receive the surplus. So there can be some nuances, but that is a fairly rare situation. And quite honestly, usually what happens is the bank who holds a mortgage on a home usually comes in and they're usually the ones selling anyway.
Okay, all right. And so let me ask you questions about the fees and I don't think, this is not your presentation, right? This is John Arnold, I think he was before.
That is, I think that was the develop, John Arnold is not
Yeah.
affiliated with our
Okay,
organization.
No, I don't need to, I just wanted to make sure. I wanted to ask a question. Are your homeowners association members able to, like, when they file a lien, right, you'd usually file the lien for them, right?
Correct.
And you can file it for fees, you can file it for violations. Who comes up with the rules about how much you can charge? So let me give you an example. One of the things that I find very particularly bad is that a homeowners association can say, hey, I don't want you to have an RV in your driveway. Okay? Now, I'm paying my mortgage, but you can't have your RV sitting in your driveway. Right?
If it's
Because
in
it
their
looks like-
recorded documents.
No, this is the homeowners association rules.
No. Generally, you cannot restrict by rule something that's not provided for in a declaration. And in a homeowners,
okay,
you would
so
need a
there's a dec-
supermajority.
Okay, but that's okay. You've got the declaration. Help me understand that. It's on my property. It's in my driveway. I own it. The house, I'm paying the mortgage. Help me understand. How about this one? You can't leave your trash can on the side of your house. You got to put it in the back. Can they assess a fee on me for that?
If the governing documents state that that is a restriction, and remember, as this woman indicated, when a developer sets up a community and they go through the process and they create the restrictions, it is a publicly recorded document, which means any owner buying into that community says, yes, I agree. It's like joining a club.
Respectfully, even when I sign the mortgage, I don't read every document. Okay? And if anybody in this room, no, actually, let's be realistic here. When people go to buy a home, okay, so we're going to give a non-government entity the ability to file a document. Where they file it at? They're going to file it at the
With the recorder of deeds for that county.
Okay, recorder of deeds. And then what I'm supposed to do when I notice that there's a homeowners association, before I sign my mortgage, I'm supposed to go to the recorder of deeds and say, you know what? You charge $25 for every day that my trash can is sitting at the end of my driveway instead of on the side of the house where there's nothing else. Or you could charge me $100 because my grass is 3 inches tall, right? And I'm supposed to know that, so it's okay. I think that's what you're saying. I'm supposed to go to the recorder of deeds and
No, typically what happens is if you're buying from a developer, the developer always provides that packet
is it
to you.
required by law
Yes.
to provide the fees, the dollar that you're going to be charged for those?
Not with respect to any penalties. Each association can set those, and that's also part of our proposed legislation, is that we're advocating that each association adopt a schedule of fees. Because you can imagine, a fine for something, in Geist might be different than something in southern Indiana.
That's my point. There's no requirement in the law that the fees be disclosed. It says there are fees, but it doesn't tell me my fees. And let's be real, homeowners associations can have a meeting and they can change the fees, right?
A board of directors that's elected could change the fees, but I would say that under the law, there is an obligation for the association to provide it, because under the current HOA Act, anybody who requests copies of the association corporate records, they're required to produce them, and that happens.
Upon request.
Yes, correct.
All right.
Senator Pohl, I was going to call him next, sorry, and then I'll come right over here.
Thank you, Mr. Chair. So I just had a question as far as these fees and fines goes, and this is to Senator Taylor's point. The fines, I guess, the violations that you're assessing these fines for, are they all also considered ordinance violations of the municipalities in which these HOAs are located within, or the counties that they're located in?
It entirely depends. So, for example, you might see an overlap where an association might say you can't have cars parked on the street overnight, and separately it might be a city ordinance. But you raise a good point, because we just did a large presentation for the city of Fishers last week, and what the residents are saying is they're so frustrated with the lack of ability to enforce their governing documents, they're now going to the city and asking the city to step up the enforcement. So again, now we're going to be leaning back more on city resources when we can take care of this issue in the HOA itself.
So if there are, I guess, if there's extra jurisdictional issues, so for example, you have violations that are not ordinance violations, also ordinance violations. So, for example, Senator Taylor brought up the idea that you couldn't have your garbage cans on the side of your house, you had to put them in the back. That likely is not an ordinance violation. That's likely going to be the aesthetic of the HOA in which these individuals, buy the house. They would have to go to the recorder's office to find the HOA documents before they purchase the home, correct? In order to find out whether or not that's a violation?
Well, I believe right now under the current law, the seller is required to provide them to a purchaser. So when you go to purchase a home in an HOA, you should be provided with a statement on behalf of the association, anything that's owed, as well as a copy of the governing documents. And I
Okay.
believe most real estate agents are aware of this, and they routinely do that.
Okay. So that's obviously a notice issue as to whether or not that happens, and I'm sure that there's a completely separate legal, remedy for individuals that may have bought into a house, into a HOA that they didn't know about. But I guess my question goes to, you can still charge for a violation under these HOA regulations, even if they're not considered ordinance violations within the municipality. So they go above and beyond. So
Yeah, it's a breach of contract, essentially.
okay. I've never lived in an HOA area. I've never bought a house there, so I didn't know whether or not that was it. So thank you.
I think I saw Senator Alexander and then Representative Bauer after that.
Yeah, thank you, Mr. Chairman. Could you just explain the difference, just for the group up here and also the public, between a HOA and a neighborhood association?
So generally, with a homeowners association, you have a declaration that specifically sets forth any covenants, restrictions, easements, and generally defines the property, what is common area, what is not, who's responsible for which portions of the property, versus a neighborhood association, which is more of, I think, a municipal setup type association of general constituents. So I don't believe neighborhood associations have similar restrictions. It's not a formal organization set up. And all homeowner associations are set up as not-for-profit corporations, generally.
Yeah, and I guess the other difference I was getting at is a neighborhood association can assess an amount that somebody would pay to belong to the neighborhood association, but generally that's voluntary.
Yep.
It's not, if you pay it, that's great. If you don't pay it, you may get shunned by the neighborhood.
Yeah, and those, we
I guess,
generally
but-
refer to them as voluntary associations.
Yeah, but
yeah.
it's not anything that they could attach or fine for or anything like that.
Correct.
So just wanted to get that out there.
Representative Bauer.
Thank you, Mr. Chairman. Sorry for all the questions. I don't know if anyone else is coming up after you, but what sort of consumer protections are in place for individuals within this covenant of a homeowners association with the HOA's ability to levy fees and fines? Who is overseeing that?
That is a great question. So we have had discussions with the Attorney General's office. So right now in the current HOA Act, there is a mechanism for any disputes to be submitted to the Attorney General's office. So for those of you who are concerned about, you know, what if we have a board who imposes too high of a fee, or we think that they're unfairly not going through the due process, there is a mechanism in the current statute that already allows for those complaints. It is a very effective process. We had the Attorney General speak to our organization last year, and we're working with them again to come back and speak. Separately in the HOA Act, there is also a mechanism for dispute resolution. So if an owner has a complaint, they can submit a notice of claim, same way that an association can submit to an owner. It initiates a conversation and allows for a settlement meeting, which we think is a great thing. I know other states have actually tried and failed at doing that, and it works here.
And just a brief follow-up, do you know how many people take advantage of that through the Attorney General's office?
I think we see a handful over the year. I will say this, and I did mention this at one point to Attorney General Rokita. They don't move very quickly. I know they have a lot of issues at the Attorney General's office. They don't move quickly, but they do investigate them, and owners are aware of the process, so they are utilizing that process.
Any other questions? Thank you very much. Appreciate your time. Come on up. Familiar face, Representative Olthoff. Good afternoon.
Yes,
Thanks for
hi,
waiting.
State Rep Julie Olthoff. So those 5% complaints come to me. I'm just saying, I'm from Crown Point and Winfield, one of the fastest growing areas up in Lake County. And so I just wanted to say there's a difference between the members of these associations. They do a pretty good job. But there's a lot of homeowners associations who don't belong to these management company groups who you pay to take care of things. So we have a lot of people who are on the boards of HOAs that really need training. And I was looking at some of the things Florida was doing as far as certifying. But then you think, okay, if you want to run for HOA board, then you got to take the training, and you think that would just hold back some of the people who would run. But there is really needed change. So I'm just here to say I'm on board with you guys. There is a lot of people who complain to me. The president is the husband, the treasurer is the wife. You go to a meeting, nobody knows how much money is in the bank. It goes on and on beyond the fines and can they take my house kind of thing. And back to your question about the CCRs are required before you buy a house in the statute. It's so many days. And it's really good if you have a management HOA that has a website. They keep the CCRs right there on the website. But that doesn't happen all the time. I have stories of we came to closing, plopped down the 200-page document. Do you want to live here or not? So they didn't even get a chance to read them. I also spoke to our county recorder who said, in her opinion, only maybe 40% of HOAs filed the current CCRs. So they're not even doing what they're required to do, and there's nobody watching. Like nobody, how do you know when something changes, you have to refile? It just isn't happening, which is why my mind went back to, it's always a training issue. It's always, do we just have them come to some traveling meeting and now we've got government training? But something really needs to give, because subdivisions are the latest form of building. They're just not even building a street, and it's all like pulled into an HOA. There's trouble with people that can't afford to replace the fountain or fix the retention ponds because nobody thought about collecting money soon, like before that happens. These are expensive things. I have talked to the Attorney General's office as well. I have a chart of how many people call. It's like the number 3 complaint call to the real estate division of the Attorney General's office. I have a bill already drafted. I was waiting for this meeting to see if I should have anything that goes in it, that the AG's office is asking for a little bit more teeth for management companies and brokerage and those kind of relationships. So I just want to say I'm on board with this, and thank you for bringing it.
Questions for Representative Olthoff? Thank you. Thank you very much.
Yeah.
Thanks for coming. Anybody else sign up to testify on this topic? I don't see any. Oh, sorry, come on up. We did not get all the sign-ups for everybody, so I'll make sure I got everybody. Go ahead.
That's okay. Thank you very much. Good afternoon. I believe it's afternoon now. Committee members, thank you for having us. I am Rebecca Richter, Chapter Delegate for Community Associations Institute Legal Action Committee, owner and board president in Whispering Woods Condominium Association in Fishers, Indiana. I have lived in Indiana condos since 1994. Being a condo owner for that length of time, serving on my current board since 2019, and being involved in CAI since 2019 has given me much perspective and appreciation over the years as it relates to both the benefits and the difficulties of association living. It is the duty of board members to enforce governing documents and maintain property values. Currently, associations' primary methods of handling matters is limited to a series of letters requesting that the issue be resolved. These requests are often totally ignored and then handled on either the owner's or the court's timeline, which can have varying negative impacts on the entire community, including financial costs incurred by the entire association, negative aesthetics, and perhaps even reduced property values. These issues cover a wide spectrum and can range from something very seemingly simple to much more serious considerations. For example, the trash cans that sometimes owners leave out for a week at a time. Allowing trees to overhang roofs, causing roof, gutter, and downspout damage for which the entire association is responsible to repair. Having heavy roll-off dumpster containers dumped and parked onto concrete driveways for which the association is responsible to repair due to the weight of the dumpster. Parking unsightly RVs, trailers, campers, large trucks, etc. for extended periods of time in the driveways. Commencing building additions that have not been approved by the association. When owners don't comply as requested, then the only other alternative in many cases is litigation that clogs the courts. It is expensive for all parties involved, and many associations simply do not have enough funds to pay those costs. I'm here today on behalf of my association to ask, and the good news is that we're not asking you for any money, okay, but we're asking that this committee please consider legislation that will expand options available to all Indiana HOAs with respect to enforcement of violations. I'm in a 20-year-old community. We have no provision for any fines whatsoever. So that is not an option for us at this point in time. As an owner and a board member, I support the proposal of legislation that includes a specific process before penalties and/or fines are imposed that will help deter these numerous occurrences going forward, help alleviate court costs and judicial dockets. And you may ask, well, how is that going to happen? Well, just consider that you're shifting the burden from a much larger pool of bad actor owners who are causing these violations and issues and clogging the courts, and you're shifting that burden to a much smaller group of board members. But you need to control that by having a specific process in place that they need to follow. Also, it would benefit the much greater and vast majority of owners and residents who do voluntarily comply with association living contracts. We are asking for your help to provide both existing and new associations better tools for today's world, enabling associations to have more effective and yet still reasonable governance. And respectfully, Senator Taylor, your comment, about you don't read the documents, we see this day in and day out, and it is unfortunate. And some of it goes back, we just had this 2 weeks ago. Realtor listed a community or a unit in our community for sale, maintenance free. We are not maintenance free. We are shared maintenance. It is low maintenance. And the association does provide for the larger things like roofing, concrete, snow, grass removal, leaf removal, but there are many things. Oh, you mean I have to replace my windows and my doors? And people they're not aware. And it causes a lot of difficulty then when they do purchase into the community because and people buy into these associations because they like the look, the general look. And if we can't enforce the general look with effective tools at our disposal that don't clog up the courts, it just makes our jobs that much more difficult. But thank you for having us. I appreciate your time and your consideration going forward, and I'd be happy to answer any questions you might have of me.
Questions, Senator Taylor?
I'll make this quick. Mr. Chairman, thank you. You brought up an interesting thing, and I never thought about this, but in a condo HOA, the issues you brought up about the driveways, which the HOA may be responsible for replacing,
Yes.
roofs,
Yes.
but so is there a separate statute for a HOA in a condo community where you might have all those common areas in it, and then versus a HOA for, I don't know if it's fair to ask you this question, and then a HOA for like a neighborhood?
It's my understanding that the Indiana HOA Act, HOA term is used interchangeably between a homeowners association, a condominium association, and a PUD, a planned unit development.
Okay.
And
I can speak to,
yes.
there is a separate HOA act. So homeowners associations are legally distinct from condominium associations.
Okay, great.
And townhome, yeah.
Okay,
So there is a separate act.
So we do have that distinction because I didn't think about that distinction. And I would assume in most of these situations, there's a common area, which is the real impetus behind, like a neighborhood may have a pool or a clubhouse or something like that. You got to maintain it. You got to pay people to work there, et cetera, et cetera, et cetera. Okay, all right.
Yes,
wanted to make
and
sure.
in a condo association, we are responsible for much more, for the vinyl siding,
Oh,
the
yeah.
masonry, the brick, the roofing, the
My
gutters.
mother-in-law lives in one of those
Yeah.
communities, and
Exactly.
she's on the board.
So it can become very expensive for the association to maintain all of this common property, all of this common grassy area, if you have a pool, a tennis court, et cetera.
Okay, thank you.
Any other questions? Thank you, ma'am. Appreciate it.
Thank you.
Did I miss anybody?
Is it possible to make additional comments?
No, Mr. Arnold, we're only going to do one time per person, or we're a little over schedule. You could feel free to stay after and chat with the committee members, though. Is there anything else from the committee before we adjourn? That's all we have to testify. Appreciate everybody's time that we went over, and I apologize. Thank you very much. We're adjourned.